In section 42(3)(a), that composition of 1%, if you will see, then they stated that any agreement entered after 1st April 2010, but the turnover will be included when you have registered that. In conditions number 2, they have stated that when you register that agreement, in that month's turnover, you have to add the total. Therefore, the question of the department may say that once you entered an agreement in the month of July, in my example, you have to bring into the tax net. You have to bring the same turnover into the tax net. That may be the argument from the departmental side. But the registered agreement is, the registration is made in the month of November, in my example. You can advance an argument stating that wherever a term is not clarified or not defined, we can take shelter, that is the internal aid. Under the interpretation of statute is called internal aid. You can take an aid, internal aid from your own statute, your own act and rule. In our own act and rule and notification, you will find the liability qua the composition as stated. Is stated that the month of registration will be taken, so you can take shelter of that. So that the involvement of goods from July till November, we can escape. No doubt, if you ask me honestly, then it is the date of execution is the date of agreement. But they have not brought any clarification and meaning in that. Otherwise, if you read other civil laws, Transfer of Property Act, Indian Registration Act, Stamp Act, then the date of execution is the entering of an agreement. Execution means both the parties came together, signed along with a witness, and came into a binding relationship. That is the date of execution. Normally, it will come. But when they have clarified by way of notifications for other purpose of computation, that the month in which you have registered that agreement, that in that month the total turnover will be included. Why you should not take the aid, that help of that meaning? Instead of taking from the month of July, we can take month of November. So that, as Supreme Court has said, as Supreme Court has interpreted that from the date of agreement, the involvement of goods is subject matter of levy. From there, the buyer and seller's relationship starts. Therefore, whatever the involvement of goods is there, after that agreement is entered, is a subject matter of levy as clarified by Supreme Court very expressly. Therefore, entering of the agreement is an important role in our computation. Clear? Now next. Coming to this 1% composition method. Coming to the composition method. Not only 1% but also composition method. As you are aware that section 42 prescribes a composition mode method in lieu of the regular method prescribed. If you are unable to, it is very difficult to go with your regular method for determining the value of goods involved in the execution of works contract, you may opt a composition method which is prescribed under section 42(3). Now in the 42(3), this says that the total contract value, on the total contract value, you can discharge, being a building contractor, 5% on the total contract value. Total contract value here means the total agreement value. Now, whether the question comes, whether any chances of, saving tax so far as the composition is concerned, is there or not? What these aspects, if you talk, that the contract value is a subject matter of levy under this composition scheme. 5% on the total contract value. As I pointed out to you, that if any additional interest is created, I was expecting Patkar साहब from the beginning. Patkar साहब, स्टार्टिंग से मैं आपको राह देख रहा था कुछ गाइडेंस मिलेगा बोल के, मैं जो अभी तक बोला है. So far as the composition scheme is concerned, the total contract value is subject matter of levy. As I clearly pointed out and explained that there are three aspects are involved. One is the land cost, second is the material involvement, and third is interest over that land. Now they are not touching that interest on the land. As I clearly explained, there are various aspects are involved, various aspects are involved in the interest of the land is concerned. So why we should not make a different agreement so far as the interest over the land is concerned to overcome these aspects? Because they are not touching this interest over the land part is concerned, neither under regular method nor under the composition scheme. The total contract value entered with the flat buyer. You think about it, keeping in mind the other laws also, Stamp Act and all those things. So when you talk about the composition scheme, the total contract value is subject matter of levy under this section 42. Now under section 42, section 42.3, 3A they have added by stating that from 1st April 2010, 1% composition is applicable if the agreement is entered after 1st April 2010. But the turnover will be taken into account in the month in which it is registered. Now here a crucial question comes to my mind, that you entered an agreement, maybe to protect your interest you have registered, that flat buyer has registered. Now this says that once you opt a composition, you cannot opt other options. You have to discharge the tax liability as per the condition prescribed in that composition by filing return also paid. But that project viability is in question mark. That is not at all, the construction has not at all started. Now, any other mechanism is provided under the law? Answer is no. Because when we talk about works contract, it is the involvement of goods and it's the measurement of tax which you are measuring either under Rule 58A or taking into a composition mode we are measuring. But really, if there is no involvement of goods is there, whether the government can take the benefit of that. Therefore, Honorable Bombay High Court in the MCHI's judgment, while interpreting this 42A, validity of the section 42.3A, they said that before us in this matter, nothing has been shown as an arbitrary aspect. Therefore, we are upholding the validity of 42.3A. That means still it is open to you to challenge 42.3A if you are able to show that about the viability, arbitrariness, etc. It is not the case that completely they have approved it. They said that in the present matter, nothing has been brought before us showing that any violation of fundamental right or arbitrariness. Therefore, we are upholding. But that means it is open to you to show the examples which I have advanced before you can be brought, showing the arbitrariness, showing the violation of your fundamental right, and can be challenged also 42.3A in this angle under the composition scheme. Several questions are coming that an agreement which is entered prior to 20th/6/2006 and the involvement of goods, the project is completed much after that. Involvement of goods prior to 20th/6/2006 is also there, after also there, and the question of assessment of that particular agreement, that particular flat, how it is to be quantified. Prior to 26/2006, my opinion may be varied by you, maybe differentiate. It's my opinion. In my opinion, when a chargeability is created from 26/2006, as I pointed out, in order to impose a levy tax, there are three aspects are must. One, charging provision, and a measurement and incidence. Here, when the chargeability is created in the statute with effective from June 2006, if any transaction is entered prior to that, even though involvement is afterwards, cannot be brought into the tax net because there was no charging provision is there. It can be explained, there are several judgments also there in a different manner. कल अगर किसी को आप एक जोर से थप्पड़ मारा होगा, वो इट डजंट अमाउंट टू हर्ट. कल ये जो चार्ज किए आप थप्पड़ दिए, इट डजंट अमाउंट टू एन हर्ट अंडर द इंडियन पिनल कोड. कल आज से एक लॉ लेके आए इन्होंने और बोले कि जो आज से अगर कोई थप्पड़ मारता है, इट विल अमाउंट टू हर्ट, 3 दिन अंदर रहना पड़ेगा. ये चार्जेबिलिटी है. ये अगर चार्जेबिलिटी प्रोविजंस ऐसा अगर है, देन इन सच सर्कमस्टेंसेस जो कल आप थप्पड़ मारा था, वेदर दैट कैन बी ब्रॉट इनटू द नेट और नॉट, ये क्वेश्चन. ऐसा बहुत सारे एग्जांपल्स हैं अंडर सिविल लॉ एंड क्रिमिनल लॉज में. सो देयरफॉर ए चार्जेबिलिटी व्हेन यू आर ब्रिंगिंग फॉर द फर्स्ट टाइम सेइंग दैट this involvement of goods will be effect and it will be deemed to be treated as a sale from 20/6/2006. So any chargeability or qua that particular transactions effected prior to that, whether it can be termed as a sale, that is the prime question which is not dealt. It is a question of an assessment. Therefore we have to take, in my opinion, no, even though involvement is involved afterwards, but since the chargeability is not created when the definitions came, I mean it was much prior to that, therefore it cannot be brought into the tax net. That is my personal opinion. Now agreement, question of changing of methods now comes from compositions to regular method to composition. This sort of questions are coming while computing the liability. Now from 1/10/2010 in 42(3)(a) they prescribed certain conditions. They says that once you opt 1% composition, you cannot switch over to any other methods. In 6 number conditions they says. That means if you are in 42(3) or in rule 58 method, you can very well jump to composition 3A, 1% composition from that method. But in such circumstances, the other conditions also there. Please keep in mind, you have to forego set off qua that particular flat, qua that particular agreement. If you have effected purchases on the strength of C form, then the liability will create on you. So all the other conditions you have to see before switching over while computing the liability. So from composition 42, you can jump to 42(3)(a), 42(3) to 42(3)(a, or from the regular method to 3A. But from 3A once you adopt, and that 3A, some frequently asked questions I came across in the website of the official website of the government. They says that it is qua project. When Bombay High Court and Supreme Court says about the agreement entered by the seller and buyer, why they are talking about the project? So the calculation or the adoption of method is in respect of a particular agreement. Nowhere it is specified any project, completion of that project till the contract, that they are talking about the contract. Means in the building, if you are having a 300 flats, the question comes whether we have to adapt the composition qua that building, qua that project, or if you are constructing a 7 buildings in a particular project, I mean, in a particular land, whether we are going to adopt one composition method for all the buildings? Answer is no. They are not specified this aspect. This is that qua the contract means qua the agreement, because in the sales definition section 2 subsection 24 they agreement to enter into a construction of a building, a construction of a flat. So it talks about a particular project. Wherever we are beneficial, we can compute, and wherever it is not into my mind, it is not the project, it is not the entire complex project, it is qua a particular contract they are talking about, composition, switching over the methods. Now coming to other questions in relation to assessment, various questions are coming. What about the TDS provisions in respect? Whether the TDS provisions will attract. If a company enters into a contract with the developer or builder, buys some flats or commercial premises, the question arises whether TDS is deductible while making the payment, because under the TDS provision in section 31, you will find the companies and the person who are registered under the sales tax law, they are falling within the ambit of this TDS provision, and they are bound to deduct TDS while making the payment. A crucial question comes. The matter was in dilemma, that was subject matter of a challenge before High Court and Supreme Court. At that time, most of the companies, they have not deducted TDS for the developer. They have not brought any provisions in this respect. What is the impact on that? Whether we can take the chance or not, or whether they are going to penalize us in this respect. So far as this part is concerned, there are several judgments under Income Tax Act is there. Wherever the method of computation was the subject matter of litigations, not deducted, then Supreme Court even says that cannot be taken into in a strict manner, and the other penal provisions or charging provisions will be applicable. So you can take the benefit of that Supreme Court judgment under the Income Tax Act qua its TDS provisions, and that liability can be escaped so far as the company who has not deducted TDS while buying the flats or office premises, not deducted because the department has not brought, or the legislature has not brought any mechanism in this respect of the builder and developer, which is a subject matter of challenge. So therefore you can take the benefit of that under the Income Tax Act. There are several judgments are there on the very issue. So therefore you can take the benefit if it at all comes, the authorities wants to charge that you have not deducted TDS, therefore you have to pay the tax at the rate of 2%, whatever may be, or along with the penalty. If such sort of so-called notices comes, you can reply in this manner, taking the benefit of the income tax judgments. Already settled judgments are there on this issue. Now the question comes, when we talks about the principal contractor, that is a builder and developer, and the subcontractor, the TDS mechanism. You are aware, in the plain language it is written in section 31 very clearly that the principal contractor should not deduct TDS from the subcontractor. Either the contract is awarded fully or a parcel is given. If a plumbing contract is given to one body, an electricity contract is given to another person, and other contract is given to other person. So either partially given or back to back is given, no TDS is required to be deducted on account of the provisions of section 31 read with 45(4). Now here also some questions came to me, that a builder on a back-to-back basis awarded contract to one contractor, but at the same time he reserves his right that the cement and steel will be supplied by him. Steel and cement will be supplied by him. Number one, we are talking about the computation of the liability of the builder in one hand as well as the contractor. Builder thereafter supplies the steel and cement and reduces the liability from the total contract value which he has awarded to his subcontractor. Reduced that one. And the balance amount is paid. The question comes now, in the hands of your developer builder, how it is to be taxed, that steel and cement. It There is a question mark in one hand. And in the other hand, in the subcontractor's hand, what is the value? The total contract value will be taken because he is discharging the liability, the contractor, subcontractor here. And as you know that under Rule 58, a developer when calculates his liability, he can reduce the subcontractor value. So if he is a registered subcontractor, you are reducing and exchanging the forms. Now the crucial question, the steel cement supplied. A unique judgment of, there are two judgments of there, Supreme Court's. Rashtriya Ispat as well as Goel's case, NM Goel's case. There they said that there are two types of relationship is entered here with. So whatever the steel or cement supplied by your developer, your builder, will be treated as a trading sales because you are deducting from the contract value. So accordingly, you have to quantify that liability. If it is brought from outside Maharashtra state, first point levy. If you have brought from local registered dealer, charge tax, then claim the benefit of the setup. But ये मत करिए कि नहीं, because I have awarded the contract, steel and cement is controlled with me by me, I am not going to pay the liability on that, the contractor in any case is paying. But NM Goel and Rashtriya Ispat, it comes in your way, therefore please keep in mind while computing this liability. And in the hands of the contractor, as if he has buyed from some other persons, you have to treat that transactions in that manner, and the liability is to be computed in the hands of your subcontractor also.